Did you fill in the dates, guys? Mr. Downs, in cause number 24, let's see, what counts are we going on? Count one only? Is that in both cases? Okay, thank you. All right, in clause number 24, DCCR 0566, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from January 28th of 2023. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Second to pull the
Quick pause. When the state says it's proceeding on count one only, that's not mercy, it's strategy. Prosecutors often narrow the case to the strongest charge to lock in a clean conviction. Less clutter, higher odds. The question is, what's being left off the table here? These are two separate felony cases, different years, different conduct. But watch how
other one up. Sorry, it takes a minute for me to pull it up the right way so I can make those notations. All right, in clause number 24, DCCR 1023, the state's also elected to proceed on count one only. It alleges you committed the third-degree felony offense of deadly conduct discharging a firearm from January 28th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they charged you with. In each of these cases, I have here on the tablets documents that have your signature on them. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization or federal law? State tenders number one in each case. It's admitted in each case. Is there any evidence that Mr. Downs is not competent? All right, Mr. Downs, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent, and you understand the nature and the consequences of those pleas.
They're being packaged together. This is where defendants quietly lose leverage. Multiple pleas at once can feel efficient, but they also stack consequences fast. Would you take a bundled deal or fight them one at a time? This line matters more than people realize. These cases will run concurrently. That means 6 years.
Clause number 24, DCCR 0566, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in clause number 24, DCCR 1023, also find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct discharging a firearm. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm, or ammunition, or about how long that lasts, you can talk with Mr. Lewis. It's my understanding, is there already a federal sentence that you're serving? So did they specifically concurrently? Okay. So I will also order that it's really up to the federal system on whether things run concurrently or not with state. I can say whatever I want, and they're going to do what they want. It's my understanding, though, that they've said that this will run concurrently or at the same time with your federal sentence, and so I will make sure that our judgments notate that as well, so that both of these will run concurrently with each other and the federal sentence. If there's something different that happens on that, that's up to them. Okay? All right, you can go back with the bailiff. Good luck, Joseph.
He's in jail right now.
All right, sir. Are you Travis? Hold on. Are you Travis Smith? So I know there have been some documents filed by Mr. Adams with regard to a mental examination. I think there was some confusion as to what you're asking for. First of all, you're hired in the case, correct? So anything that is filed requesting a court-appointed examination needs to include an affidavit of indigency sworn to. So I need you to get that taken care of and attached to anything you filed if you haven't already.
Years total, not 12. Same sentence, same clock. For defendants already facing time, concurrency can be the difference between hope and hopelessness. And here's a reality check most people don't know. State judges can recommend concurrency with federal time, but the federal system gets the final say. The judge even admits it. She can write it down, but the feds will do what they want. That uncertainty, that's brutal.
Okay. 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 I mean, there are times when someone can hire an attorney, but they run out of money or whatever it is. If that's not the case and he's not indigent, then I'll reset the case to give you a time to have someone get that examination taken care of. But if it's a hired case and they're not indigent, that would be something that the defense would take care of. So,
allow that. I wrote the order.
I guess what I'm saying is I'm not going to sign an order having the county pay for it unless there is an affidavit.
The judge is drawing a hard line. No affidavit of indigency. No county-funded exam. Translation. If the defendant isn't legally considered broke, the court isn't footing the bill, the defense is. This happens more often than people think. And it's a reminder that hiring a lawyer doesn't automatically mean the system pays for everything else. Do you think that's fair, or does it create an uneven playing field?
Affidavit of indigency.
I'm not asking. That's what I'm saying.
I don't know that. I mean, I'll order, but I don't know that you need me to order it. If it's your client, you can have them examined. Is there? You know what I'm saying? Do you need me to order it? If it's
I can get them examined. It's just present conflict.
Okay, but I don't think I need to order it. I think you can just have a doctor go if that's between. Yeah. So I'll reset it to give you some time to get someone to go out there and take care of whatever examination that you need to, and then we'll get an announcement at the next court date.
Okay, but what I want to have, put him somewhere where he can't afford this.
Well, we got to get the examination. Let's take one step.
Everything hinges on competency. If the evaluation shows he's not competent, the judge suddenly has much broader authority, including sending him to a treatment facility. Until then, the court is basically saying, step one first, everything else later. This is the calm before a potentially massive shift in the case.
At a time.
Yeah,
let's get the evaluation done, because if he's not competent, then I can order him go to the appropriate facility. All right. So you get the examination taken care of. So the doctor is going to come visit with you and just talk to you about your case and what's going on, and make sure you understand everything, and then we'll go forward after that, okay? Because that's what we're going to take care of. That's what your lawyer is recommending. So that's what we're going to do. So you can go back with the bailiff. Mr. Adams, the quicker you get that done, the better, so that whoever's going to do it can get out there and get that taken care of.